The court meets this afternoon and will meet tomorrow morning to hear the oral observations of the parties on the request submitted by the Republic of South Africa on May 10, 2024, for the indication of additional provisional measures and the modification of previous provisional measures in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. For reasons made known to me, Judge Tomka is unable to be present on the bench for the duration of these hearings. I shall now record the principal steps of the procedure in the present case. On 29 December 2023, the Government of South Africa filed in the registry of the court an application instituting proceedings against the State of Israel, alleging violations by the letter of its obligations under the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, to which I shall refer as the Genocide Convention. In particular, South Africa contended that Israel, in conducting military operations in and against Gaza in the wake of the attack of Israel by Hamas on October 7, 2023, has breached and continues to breach its obligations under the Genocide Convention. To found the jurisdiction of the court, South Africa invokes Article 36, Paragraph 1 of the Statute of the Court and Article 9 of the Genocide Convention. The application contained a request in the indication of provisional measures, pursuant to Article 41 of the Statute of the Court and Article 73, 74, and 75 of the Rules of Court. In its order of January 26, 2024, the Court indicated various provisional measures addressed to Israel. By letter dated February 12, 2024, South Africa submitted to the Court what it referred to as an urgent request for additional measures under Article 75, Paragraph 1 of the Rules of Court, in connection with certain developing circumstances in Rafah. By letter from the Registrar dated 16 February 2024, the parties were informed that the provisional measures indicated by the Court in its order of 26 January 2024 were applicable throughout the Gaza Strip, including in Rafah, and that the recent developments did not therefore demand the indication of additional provisional measures. The Court also emphasized that Israel remained bound to fully comply with its obligations under the Genocide Convention and with the said order, including by ensuring the safety and security of the Palestinians in the Gaza Strip. On March 6, 2024, South Africa filed a further request for the indication of additional provisional measures and/or the modification of measures previously indicated by the Court in its order of 26 January 2024. Based on the alleged change in the situation in Gaza since the indication of the first set of provisional measures. In its order of March 28, 2024, the Court found that exceptionally grave recent developments, including the desperate level of food insecurity, the rules. The Court concluded that the provisional measures indicated in the order of 26 January 2024 did not fully address the consequences arising from this change in the situation, thus justifying the modification of those measures. In the operative clause, the Court reaffirmed the provisional measures indicated in its order of January 26, 2024 and indicated additional measures. The Court indicates that the State of Israel shall, in view of the worsening conditions of life faced by Palestinians in Gaza, in particular the spread of famine and starvation, take all necessary and effective measures to ensure, without delay, the unhindered provision of, at scale, by all concerned, of urgently needed basic services and humanitarian assistance to Palestinians throughout Gaza, and ensure with immediate effect that its military does not commit acts which constitute a violation of any of the rights of the Palestinians in Gaza as a protected group under the Convention on Genocide. Today's hearings concern the urgent request filed by South Africa on 10 May 2024 for the indication of additional provisional measures and the modification of provisional measures previously prescribed by the court in the case. The Registrar will now read out the passage from the request specifying the provisional measures which the Government of South Africa is asking the court to indicate. You have the floor, Mr. Registrar.
Thank you, Mr. President. I quote, 1. The State of Israel shall immediately withdraw and cease its military offensive in the Rafah Governorate. 2. The State of Israel shall immediately take all effective measures to ensure and facilitate the unimpeded access to Gaza of United Nations and other officials engaged in the provision of humanitarian aid and assistance to the population of Gaza, as well as fact-finding missions, internationally mandated bodies or officials, investigators and journalists, in order to assess and record conditions on the ground in Gaza and enable the effective preservation and retention of evidence, and shall ensure that its military does not act to prevent such access, provision, preservation or retention. 3. The State of Israel shall submit an open report to the court, A, on all measures taken to give effect to these provisional measures within 1 week as from the date of this order, and B, on all measures taken to give effect to all previous provisional measures indicated by the court within 1 month as from the date of this order. End of the quote.
The Registrar, immediately after the filing of the request for the indication of additional provisional measures and the modification of previous provisional measures, the Registrar transmitted an original copy thereof to the Government of Israel. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same article states that the court shall proceed to a decision on the request as a matter of urgency. This imperative must, however, be balanced with the need to fix a date of oral proceedings in such a way as to afford the parties an opportunity to be represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings, during which they could present their observations on the applicant's request, had been fixed for Thursday, May 16 at 3 p.m. I would now like to welcome the delegations of South Africa and Israel, and I note the presence before the court of the agents and counsel of both parties. This afternoon, the court will hear the single round of oral argument of South Africa, which has submitted the request for the indication and modification of provisional measures. It will hear Israel tomorrow morning at 10 a.m. For the purposes of the single round of oral argument, each party will have available to it a 2-hour sitting. In this first sitting, South Africa may, if required, avail itself of a short extension beyond 5 p.m. today in view of the time taken up by these introductory remarks. Before I give the floor to the agent of South Africa, I wish to draw the parties' attention to practice direction 11 Roman, which states as follows, I quote, In the oral pleadings on requests for the indication of provisional measures, parties should limit themselves to what is relevant for the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the Court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose. I now give the floor to the Agent of South Africa, His Excellency, Mr. Vusimuzi Madonsela. You have the floor, Excellency.
Mr. President, distinguished members of the Court, it is an honor and a privilege for me to appear before you on behalf of the Republic of South Africa. I wish to thank the Court for setting this matter down for an oral hearing on the earliest possible date, recognizing the extreme urgency of its circumstances. Since its initial application, South Africa found itself compelled to return to this Court, both in February and March 2024, to request for the indication of additional provisional measures to prevent Israel's persistent acts of genocide against the Palestinian people in Gaza. Sadly, South Africa is yet again compelled to return to this Court in recognition of its obligation under the Genocide Convention due to the continuing annihilation of the Palestinian people, with over 35,000 now killed and most of Gaza reduced to rubble. Despite the short notice of this oral hearing, South Africa has traveled here today to do what it can to urgently stop the ongoing genocide. The gravity of the attacks requiring urgent and speedy proceedings to preserve the rights of the Palestinian people, a commitment which South Africa takes seriously. Israel is escalating its attacks on Palestinians in Gaza, and in so doing is willfully breaching the binding orders of this Court. Israel similarly breaches the binding resolutions of the United Nations Security Council, erroneously believing from the lack of countermeasures by the international community that it is exempt from having to respect international law. This institutionalized impunity has led Israel to engage in this genocide, which has shocked the conscience of humanity. South Africa is mindful that the present genocide operates in denial of the Palestinian people's inalienable right to self-determination and collective right to return to their homes in Palestine. This genocide takes place within the context of the ongoing Nakba, the 76th anniversary of which was celebrated yesterday, the continued forced displacement of the Palestinian people, the erasure of Palestinian presence in Palestine, and replacement with colonial settlers. A criminal process entrenched and maintained by 76 years of apartheid and 56 years of illegal, belligerent occupation. Undoubtedly, the ongoing scenes of Palestinians being forced to repeatedly flee for their lives is only reminiscent of the Nakba of 1948. It is a continuation of it. 7 months ago, South Africa could not have imagined that Gaza would now be mostly wiped off the map. It could not foresee that every family, every neighborhood, every class of students, every workplace would be pulled apart, killed, maimed, displaced, malnourished or starved. South Africa had hoped, when we last appeared before this Court, to halt this genocidal process, to preserve Palestine and its people. Instead, Israel's genocide has continued apace and has just reached a new and horrific stage. Israel has sought to hide its crimes through the weaponization of international humanitarian law. It pretends that the civilians it ruthlessly kills through its 2,000-pound bombs, through its targeted airstrikes, through its artificial intelligence systems, through its executions, are human shields. This whitewashing of Israel's genocide misses the key and fundamental element, that of the massive and still mounting evidence of Israel's genocidal intent. Documents and videos of Israeli parliamentarians and military leaders calling for the destruction of the Palestinian people in Gaza, incitement by Israeli civil society and leading public Israeli figures, all collectively supporting the genocide and its continuation. Israel continues to show utter contempt for Palestinian life, operating with impunity. South Africa has no other option than to once again seek protection in the halls of justice for the fundamental right of the Palestinian people to their existence. Although this present application was triggered by the unfolding horrific situation in Rafah, Israel's genocidal onslaught across Gaza has intensified over the past few days, also warranting the attention of this court. With that, Mr. President, I respectfully wish to request you to invite Professor Von Loh to set out South Africa's substantive legal arguments. I thank you.
I thank the agent of South Africa for his statement. I now invite Professor Von Loh to take the floor. You have the floor, sir.
Thank you, sir. Mr. President, members of the Court, it is a privilege to appear before you and an honour to have been entrusted with the presentation of this part of South Africa's submissions. This is not a routine case. It's not even a routine case on the use of force or on international humanitarian law. South Africa is here because the Palestinian people are facing genocide in Gaza, and your previous orders have not succeeded in protecting them against that. The court held in January that the Palestinians have a legal right to protection against genocide, and that South Africa had shown that there was a real and imminent risk to the irreparable violation of that right. The court issued an order because it considered it necessary to protect the Palestinian people against genocide, and it issued a further order in March. But whether because of a lack of clarity as to precisely what the orders require, or because Israel chooses to ignore them, they have not been effective. The United Nations has a framework, including the Security Council and the General Assembly, for addressing international disputes. But this part has not worked well in this case. And South Africa respectfully asks the court to reassert its authority and its role in this framework. South Africa has considered the technical legal requirements for provisional measures, change in the situation and so on, and will address them. But the essential point is that the court has the power to act, to ensure that its previous orders and its eventual judgment will not be worthless, and that the Palestinian people will be protected, and that it needs to exercise that power now. Israel's action is directed against the Palestinian people throughout Gaza and the West Bank. South Africa's request was initially focused on Rafah because the imminent prospect of death and suffering on a massive scale resulting from Israel's attack. But since that request was made, it has become increasingly clear that Israel's actions in Rafah are part of the endgame, in which Gaza is utterly destroyed as an area capable of human habitation. This is the last step in the destruction of Gaza and its Palestinian people. It was Rafah that brought South Africa to the court, but it is all Palestinians as a national, ethnic and racial group who need the protection from genocide that the court can order. We've heard expressions of outrage that anyone could accuse Israel of acting in this way. We've heard assurances that Israel was doing everything in its power to avoid civilian deaths as it exercised its claimed right of self-defense. We've heard boasts that Israel's army is the most moral army in history. And we've heard denials that there is famine in Gaza. For months, people, particularly in the West, have appeared unwilling to accept that the accusations are true. How could people who look like us and sound like us possibly engage in anything like genocide? But the evidence has to be faced. My colleagues will take you to that evidence, including evidence of continued bombings, attacks on people in so-called safe areas to which they've been directed by Israel, attacks on aid convoys, and of mass graves and the horrors of which the corpses speak. There is no credible argument that this catastrophe is not real. The court has already found a real and imminent risk of the violation of the rights of the Palestinian people to protection against genocide. The court is aware of the statements of the United Nations Secretary General, of the President of the United States, of heads of state and foreign ministers from around the world, and of the heads of international aid agencies. They, and the personal accounts and the news footage that emerges from Gaza, tell a consistent story of unimaginable horror. And it continues as we speak. Most of Gaza has been razed. The survivors who are from time to time allowed to return to their homes are returning to rubble, with no homes, no running water or electricity or sewage or other working infrastructure, and with the few possessions that they've managed to carry with them on carts or cars as they're pushed from one so-called safe area to the next. If the court does not act now, the possibility of rebuilding a viable Palestinian society in Gaza will be destroyed, at least for the lifetime of those who survive the current horrors of Gaza. The details are not always easy to verify because Israel continues to bar independent investigators and journalists from entering Gaza. And over 100 journalists who were in Gaza have been killed since the Israeli attacks began. But Israel cannot block investigations by independent investigators and then say that the court cannot proceed because there is insufficient evidence against it. The court has to deal with this case on the basis of its appraisal of the best evidence available to it. Israel may again invoke its claimed right of self-defense, but it does not address three glaringly obvious points. First, the right of self-defense does not give a state a license to use unlimited violence. No right of self-defense can ever extend to a right to inflict massive, indiscriminate violence and starvation collectively on an entire people. Second, nothing, not self-defense or anything else, can ever justify genocide. The prohibition on genocide is absolute, a peremptory norm of international law. Third, the court ruled in 2004 that there is no right of self-defense by an occupying state against the territory that it occupies. The key point today is that Israel's declared aim of wiping Gaza from the map is about to be realised. Further, evidence of appalling crimes and atrocities is literally being destroyed and bulldozed, in effect wiping the slate clean for those who've committed these crimes and making a mockery of justice. The court is not powerless, and South Africa submits with respect that it must do something to assert not only its own authority, but the authority of international law. South Africa submits that in order to secure the entry and distribution of food and humanitarian supplies and to save lives, a halt to Israeli military operations across Gaza is essential. The overwhelming weight of opinion among states and international organisations is the same. A halt to military operations in Gaza is necessary to comply with the previous orders that the court has already imposed. If Israel continues to deny that its bombing and shelling and military